this disclaimer, which is think hard about the rules of compliance that you have within your profession and try and adapt them as best you can to the social space. Social media law is evolving, which makes it a big challenge for business. And for the longest time, a lot of businesses have struggled with, do we go into social or don't we go into social? I think every business understands now, and every institution, every nonprofit understands now, they need to be in the social space because that's where the conversation is taking place. And now they're struggling with, how do we do it in a compliant fashion? You certainly should have a social media policy for your company. You should have social media training for your employees. And your attorneys as well have got to make sure that they're staying on top of the evolving law within the social media space. What I've seen, unfortunately, is that too many attorneys have not, and as a consequence, a lot of the advice they've given in this space has been wrong. Folks have got to do a lot of catch-up to understand what's taking place in social media and what the do's and don'ts are, taking a look at what the Federal Trade Commission has to say, what the National Labor Relations Board has to say, or if you're in Great Britain, for example, the Advertising Standards Authority. Regulatory agencies are beginning to understand the space and provide guidelines that have got to be digested and understood to make sure that you're marketing in a proper fashion. Marketing is a lot of fun until the lawyers show up, and the lawyers always show up, especially when we're talking about business. So understand that you can't delete something in digital, and you can't delete something in social. You can certainly take measures if you've discovered that you've sent out something wrong to correct it, but rest assured, even if you delete it, someone will be able to find it. And so you've got to really think hard before you send that tweet out to make sure that you're protecting your brand, protecting your reputation, and also staying on the right side of the law. And that goes back to understanding what the law is, getting that policy in place, and doing ongoing training, not one-time training. One of the biggest pieces of social media guidance that you should be familiar with is guidance that was issued quite some time ago by the Federal Trade Commission, specific to social media marketing. And what it has to say is something that a lot of the biggest brands have missed, which is that if you are a brand and if you are engaging bloggers in the social space, you have a duty. The brand has a duty to inform that blogger, and that blogger could be your own employee who's just chatting on his or her own Facebook page. But you have an obligation to inform that blogger of their duty to disclose material connections in a clear and conspicuous manner, and be clear about the fact that clear and conspicuous is not a link, it's not a tab, it can't be simply something in your profile biography. What the FTC has said pretty emphatically is that when you make a disclosure of a material connection, meaning that connection between an employer and employee, or that connection between a sponsored blogger and the brand he or she is blogging for, it's got to be clear and conspicuous. And what the FTC has said by that is it's got to be as close as possible to the message that is about the sponsored product or the sponsored service or the sponsored brand. And it's got to become very obvious for the consumer that that tweet or that blog post isn't just a casual one, but there's some relationship between the person sharing the content and the brand that they're sharing content about. In the United Kingdom, the Advertising Standards Authority, which plays a similar role to the FTC, has adopted a principle known as obviously identifiable as marketing. And so that's very close to the clear and conspicuous standard that the FTC has put into place. So there's kind of this merging of disclosure requirements internationally, which is something positive to see. In 2012, Nike, obviously one of the biggest brands, strayed from what the Advertising Standards Authority in Great Britain has said, which again is similar to what the FTC says, about the duty to make marketing obvious as marketing. And in this particular case, a soccer player, one of the highest paid soccer players in the world, was engaged by the brand Nike to tweet about their products, Nike's products. And yet, unfortunately for this great soccer player, he wasn't apparently advised as to the way in which the disclosure should appear. And both the ASA, the Advertising Standards Authority in Great Britain, and the Federal Trade Commission in the United States have agreed that one way in which a blogger can alert the public in a tweet about the fact that a communication is a commercial communication, a marketing communication, is simply by adding hashtag ad, or hashtag sponsored. But both regulatory agencies say that they'll look at the totality of the circumstances. And Nike's protest that it should have been obvious to everyone that this soccer player was someone that had a connection to the brand, the ASA said that wouldn't be so obvious. With a player who's got over 1 million people following him on Twitter, they said it would be unlikely that everyone would understand that connection. In fact, if you looked at Wayne Rooney's profile, you saw nothing that disclosed the connection to Nike. And in fact, before this particular tweet that you're seeing on the screen, that was the genesis of a complaint against Rooney, there was really nothing to establish the fact that there was a connection. So when you're in this space as a marketer, understand that you as a marketer, on behalf of a brand, or you as the brand, have a duty to inform bloggers who you may sponsor in one fashion or another. And the FTC has said there's no dollar amount that triggers that duty to disclose, but rather a sense from the public. Would the public change their view of a communication if they knew of the relationship that existed between a blogger and a brand? If they would, the duty to disclose is there. And again, both agencies, regulatory authorities, say that they'll look at the totality of the circumstances, which means it's a fancy way of saying it's a case-by-case analysis. Folks might be familiar with the phone dog Noah case, a case in which a gentleman left his company only to find that when he left, he wanted to take his Twitter account, and his company said, "Not so fast, that belongs to us." And therein started a lawsuit valuing that Twitter account at about $340,000. And it may seem funny, but that sort of dispute has expanded to disputes about who owns an employee's LinkedIn account. And suddenly that gets everyone's attention when someone might say, well, be dismissive about a Twitter account, but when it comes to their own LinkedIn account, that's a whole different matter. What this dispute stands for, the proposition this dispute stands for, from my perspective as an attorney, is that there is real business value now to social media and social media accounts. Business recognizes it. And as with any business asset, folks should have a clear understanding of the relationship, who owns what, and what happens when there's a parting of ways. Again, you need to talk with a lawyer from your own jurisdiction if you have a specific legal question concerning this, but generally speaking, that's a understanding of that particular issue. Know that regulatory agencies are themselves being very social. The FTC, when it announced its settlement concerning Facebook and a dispute it had with Facebook's privacy changes, the FTC had a tweet chat about it. So while they were having their press conference, they were also having a Twitter chat. I happened to send the FTC a tweet, and within minutes, they sent me, within 2 minutes, they sent me back a reply which said that the lesson for the Facebook dispute was that you've got to honor your promises in the social space, particularly when it comes to protecting consumer privacy, and that you need to do privacy by design. And that's a new phrase, and what that means is that you've got to make sure that at every step of the way in your marketing and in your product design and service design, you're thinking about how best to protect the privacy of the consumers you interact with and the data that you get a hold of. And the FTC said it's a good practice to have someone within your organization who has that regular responsibility. Know, too, that you have a keen obligation when it comes to children and online marketing. And in particular, under the Children's Online Privacy Protection Act, there's a special obligation to children under the age of 13. And that obligation is the necessity of obtaining verifiable parental consent before a business attempts to collect, gather, or share any information that's identifiable to a child. And that even includes photos of a child, the voice of a child, and it requires that parental consent be verifiable and be accomplished beforehand. The FTC has some great information at its website at ftc.gov that goes through in great detail how one can satisfy that requirement. Everyone wants to do a contest, a sweepstake on social media. Understand that when you do, not only do you have to abide by the terms of service of the particular social network, but once you've satisfied that set of requirements, understand that laws in your nation, laws in your state may well have reporting obligations. It's one of those areas where consulting with a lawyer from your jurisdiction is certainly a good idea. Truthfulness and transparency are two of the guiding principles that will keep you out of a lot of problems when you're marketing. If you fall astray of either of those, you will not only be breaking the ethics of social media, but you'll likely be breaking the law as well. Everyone wants to know where online they can go for a good social media policy, and many just say, well, I'm going to go online and get a policy from this brand or that brand. Understand that most of the brands that may have social media policies online today are likely unlawful. When I say they're unlawful, in the United States at least, the National Labor Relations Board has been very proactive about scrutinizing social media policies, and very many of them, if not, I would have to say most of them, run afoul of what the National Labor Relations Board has had to say on the subject. It's an evolving area of the law, but what used to be a simple practice of putting warm and fuzzy language about being respectful and keeping confidential information confidential, those statements may seem very innocent and very innocuous, but depending on the circumstances, even those sort of statements in a social media policy may be unlawful if they have a chilling effect on the right of employees to speak in a concerted fashion about the terms and conditions of their employment. Bottom line is, writing a social media policy has become much more complicated as regulatory authorities have understood more what's happening in the social space and act to protect existing rights under existing law. I'm happy to answer questions that folks might have, but any questions that are asked, I've got to remind folks, as I did at the very beginning, that I can't give you legal advice, and if you have a specific legal question, you need to talk to an attorney from your jurisdiction. I certainly, however, am glad to talk in a hypothetical fashion about some of the overarching issues that touch on social media law. Thanks, Lauren and Ty.
Hey, Glenn, this is Kevin Dean. It's nice to be back on the line with you again.
Hello, Kevin. I'm sorry. How are you?
Hey, I'm doing fantastic.
Great, great.
Hey, I've got a few questions for you that have come in from some of our attendees. The first one has to do with, do you have any examples of ways that online advertisers can safely make disclosures clear and conspicuous?
Well, it's a very, very important and good question that you're asking, Dean, because it's the one that gets brands into the biggest trouble most. And what has been said by the Federal Trade Commission, which calls itself the nation's online consumer protection agency, and what's been said by the Advertising Standards Authority in Great Britain, just by way of a European example, and in the rest of the world too, there seems to be a convergence on this point. Making a disclosure that's effective has got to be in close proximity to where a statement about a brand or a product is, and if it's in the context of a tweet, simply using hashtag ad or hashtag sponsored may be effective, although most regulatory agencies say we're going to look at the totality of the circumstances. But understand what doesn't work. A tab doesn't work, a link doesn't work, generally speaking. It's got to be obvious, an obvious statement in close proximity to a message, a communication that's advertising in nature to let everybody know this isn't just John Q. Public, but this is really someone who has a connection to the brand in some way.
Great, thanks. Another question about the Children's Online Privacy and Protection Rule. What are some things that individuals who operate websites, mobile developers, and ad networks can do to prepare for some of the upcoming changes in regards to this
Well, Dean,
Just
what they really need to do is, again, the Federal Trade Commission at FTC.gov has got a ton of information on their website, and it's drudgery to have to go through and read a lot of this material, but I understand if you get it wrong, the penalties can be quite substantial. And the core requirement is the requirement of verifiable parental consent before any gathering of information relating to a child takes place, any storage, any sharing of such data, and the FTC goes through different methods of what would be acceptable, verifiable methods, from whether it's as some sites now will do to say we're going to charge a credit card for $1, or we want some sort of a scanned signature. It's a requirement that does impose a real responsibility, and what folks also have got to understand that the notion of saying, well, I had my mobile application built by somebody else, and so the fact that it failed to abide by the Children's Online Privacy Protection Act won't hold muster, because what the FTC has also said is that the responsibility to follow these rules can't be abdicated to someone else. And so if you, for example, have had a mobile app developed that doesn't adhere to the Children's Online Privacy Protection Act, not only can the developer be held liable, but also the person who marketed the app and the person who sponsored the app. So real serious responsibilities come along with this.
Yeah, it sounds like it. Thanks. So here's another question, Glenn. Let's say that a company and their employees agree up front on who owns social media accounts in writing. Is that sufficient to cover all requirements, or is there anything else that's needed?
A written agreement between the parties is really the best way. You put it into writing so that there is no misunderstanding about it. That's really the best way to go at it. And there can always be a legal dispute, but if you have an agreement in writing, that particularly one that's been reviewed by legal counsel, it should give greater certainty to the parties.
Well, Glenn, it's interesting as you talk about the complications and the hazards legally that come from putting together a social media policy. Do you think it's really do you think companies should really bother with putting together a social media policy, since it's so complicated and always changing?
That's a good, fair question, Dean. Companies should certainly have a social media policy. But what they have to do is take a look at what the National Labor Relations Board has had to say on this subject, because what the National Labor Relations Board is principally concerned about isn't some fundamental right of free speech, which people often confuse it for meaning. Instead, it is a specific concern to the National Labor Relations Act that speaks about the right of employees to speak about the terms and conditions of their employment in a concerted fashion, and a prohibition against business having anything or doing anything that has a chilling effect on that very broad right. And so that's where I made note of the fact that even something as simple as saying be respectful in the social media policy, how could that possibly be considered unlawful? Well, if there aren't parameters set to it, if there aren't limitations set on that be respectful, the National Labor Relations Board has said that very statement could have a chilling effect on the right of employees to speak freely about the terms and conditions of their employment in that concerted fashion, which is the violation of the National Labor Relations Act. So it's gotten, unfortunately, very complicated.
So with all the complications, what's your best advice for companies? What should they do?
The best advice is to understand that social media marketing is part of their overall business plan, should be part of their business investment, and everyone talks about how social media is free. It's not anymore. Not if you're using it for marketing. It requires real training. It does require legal counsel, and it requires auditing of your practices, and the training has got to be ongoing. So you need to look at it more as this evolution from social media to social business, which means incorporate it into your training. It's not fair to your employees not to give them guidance, not to give them training, and not to give them supervision that helps them get it right.
Great advice, Glenn. You talked about you bring up an interesting topic, and that's about auditing. What are your thoughts, and what are some guidelines as it comes to e-discovery in social media?
Well, that's and for folks who might not understand e-discovery, and that's just very broadly the notion of if there is a dispute between your company and another company, the other company may, in litigation, require you to provide them with information concerning your social media accounts. And folks have got to understand that uh, even aspects of their social media accounts which they may consider to be private during litigation are very likely to become public. And that's a proposition that applies to traditional marketing and traditional communications as well. Uh, if I'm in a lawsuit with someone, it would be typical for me to ask a judge to give me the right to see all of their communication, all of their business communications, and possibly even some of their personal communications if it might be relevant to the um, litigation at hand. What becomes more complicated when we're talking about social media, though, is the ability to resurrect this material. And folks have got to understand that when litigation is contemplated, when litigation is underway, there is typically a requirement that the parties preserve evidence. And in one particular case, an attorney had seen some things on his client's Facebook page and suggested that he clean up his Facebook page. He was sanctioned along with his client several $100,000. They had a civil lawsuit that they had received a substantial award in connection to a wrongful death case. But once the court learned and the opposing counsel learned of the deletion of e-information, the court wound up sanctioning to the tune of several $100,000 both the lawyer and his client. And what the opposing counsel had done was retained a forensic expert who was able to say there were various deletions of various photos that did occur on the site and on a given date, and it was certainly within the court's view a time in which material should not have been tampered with at all. So understand that social media, which may seem to be like this fun place, a place that doesn't have to follow all the rules of law, it does, especially when it's being used for social business and social marketing. Hey, Dean.
Okay, I don't really know what happened there with Kevin Dean, but
I'm still with you.
okay, so we're
Sorry?
just gonna go ahead. Yep, I can hear you. Can you hear me, Glenn?
I can.
Okay, so I guess we're just gonna go ahead and wrap up with that. Thank you so much for speaking today. You did an excellent job, and you had some really good points to make, and you answered questions very well. So if anyone does have any further questions, feel free to send them our way or send them to Glenn, and we can try and get your questions answered. Our next webinar is going to be on Thursday, June 6th. It's the first Thursday of every month. We don't have a speaker lined up quite yet, but thank you everyone for coming out and listening. This was actually one of our best webinars so far. We had a really great audience, and it was very high interest. So it's a very good topic. We really appreciate your time, Glenn. Thank you for
Thank you,
coming.
everybody.
All right, we'll see you next time. Thank you.
Bye bye.